restrictions and safeguards into the purchase and sale of metal across the state of Georgia. They include, having to take your picture, a description of the metal you're selling, your driver's license, get your name, a picture of you with the metal, and then the last piece that they had was that a secondary metal recycler could not give cash for metal. When I went to visit this facility, there were several people that came in and they sold, scrap from aluminum cans to, just you name it, they would bring it in. And I saw somebody, and they had to write a check for, it was like around $12. Well, believe it or not, some people in my district, not only do they not trust the government, they don't trust banks either. So they don't have bank accounts, and they go to try to cash their check, and it can cost them up to $8. So you're looking at $12. It costs you $8 to get the cash or get the check cashed, and so, we started this process of what's a number that we can put that we feel comfortable allowing metal recyclers to give, and we landed on $100. So a secondary metal recycler can give a person $100 per transaction, and we limited it to 2 transactions per day. When you look at all the deterrents that are in place for metal theft, and we think that the cash piece is probably the least of all. But if we're wrong, we have a sunset on this bill, and we can address it then. But just for the committee's knowledge, several states around us do allow cash payments for metal. I think Alabama's 500, Florida may be 1,000, and when we first started, all the stakeholders were generous to come together. We thought about this, and this has been probably 2 months worth of work. We have carve-outs in the bill that would prevent a secondary metal recycler from giving cash for catalytic converters, for air conditioning coils, or for types of copper wire, for a battery, and for communications copper. These are the items that they believed were most likely to be stolen, that were most stolen in the past, and so didn't want to give cash for those. And that's the main part of the bill, and I'm happy to answer any questions.
Thank you, Senator Hatchett. I've got a flashing light here, but you hit on what I wanted to make sure that we were certainly vocalizing here, is that these cash payouts are still prevented for the sort of highly the pieces that are more times than not stolen, and so run through those again. Which ones are those that we're not allowing for the cash payout?
Okay, so it's on. Let me get the line number here. Looks like it starts on line 158. Goes into no more than $100. Then it says 161. You cannot pay cash for catalytic converters. 163 for utility wires, communications copper, copper wire, or for a battery.
Very good. I recall in subcommittee, and I know the subcommittee chair is still working on a amendment for this bill, so he'll be here shortly.
Yes.
A small amendment. The question was raised about the communication copper wire. Is the definition going to capture that Ethernet cord? Do you know?
Well, I don't believe it would capture the Ethernet cord here, but that was I guess the issue in subcommittee was we had a civil asset forfeiture provision which stated that if you were in possession of communications copper, it would be used communications copper, it would be presumed to be contraband, and that was where the Ethernet cord or the laptop cord came out, and that's actually been taken out of the bill.
Now, the whole civil asset forfeiture piece has been removed from the bill entirely, right?
That's correct.
All right, very good. I'm gonna give it to the committee now to ask questions. Appreciate your answering these. Chairman, administration.
Thank you, Mr. Chairman, and Senator, I wasn't in subcommittee, so I may be asking some questions from ground that's already been covered, but I recall trying to prosecute these before the change in the law that the General Assembly made, and it looks like some of the language that is in here includes safeguards similar to what we had in the pawn industry, where the seller, even a video or picture of their face is taken at the time that they do these, and that's undisturbed by this. So if cash payment's made, you're continuing to get all those records about who that seller is, and if there needed to be law enforcement follow-up after the fact, you got the image of the person, looks like the vehicle tag information, all kinds of identifying information, despite the fact that it's a cash purchase that would be made by the recycler. Is that correct?
That's correct. We have not changed anything else with that except for the 2 cash payments a day of $100 or less.
All right, thank you.
Representative McLaurin.
Thank you, Mr. Chairman. I'm nostalgic for subcommittee when this bill was thinner and more manageable.
One of the most entertaining subcommittees I've ever been a part of.
That's the purpose I'm here, because it's not to win votes. So this detached catalytic converter piece to the bill. We just had a floor discussion today about penalties and the necessity of increased penalties. My understanding is the way that this is structured, the new section 1-2, that this would basically be prosecuted the same way as receiving stolen property, that there's a standard $1,500 threshold in the penalty section for that, for a felony, and that all this would do is create a new offense that would basically be duplicative of the amount of exposure you would get for a, whatever the amount of property would be if it were stolen. Is that basically right?
And you're asking about section
1-2, lines 66 to 85. Do I have the right LC? It's
Yep.
0536?
Yep.
Yeah.
I apologize. I actually just received this committee substitute when I was walking in, but I'm trying to realize which part of the bill they put in.
Can I ask you who they is?
Members of the committee. But will you ask your question one more time? Sorry.
Sure.
I got it
So
now.
the new section 1-2 that we're both just looking at for the first time, 66 to 85, it appears to me to be duplicative of a charge for receiving stolen property. So my sense is that this would be a new offense that would essentially double the amount of exposure you would have corresponding to that statute.
I don't necessarily think it would double the amount of exposure.
Well, if it's prosecuted the same way and it's an additional offense, that's my only
Yeah,
logic on that.
and this is in response to the widespread catalytic converter theft that we're seeing across the state, and I do think it is strengthening that provision.
Let me jump in and help you out there, Senator. In subcommittee, there was a lengthy debate about whether it would be necessary to have just a per se crime to have a catalytic converter. And so, as I recall, the chairman was hesitant about having just a per se crime to have a catalytic converter in your possession. So, this provision, particularly 75 through 81, as I read it, is constraining it to the times when she should know or should know was stolen. So it tracks the same language as unlawful possession of stolen property. That is the purpose of it, but it does create liability then if a person should have known that the catalytic converters were stolen.
Thanks, Mr. Chairman. And I guess what I'm trying to flag for the committee is that it appears, and so this wasn't in the last version. The last version was all the cash trade for metal stuff, right?
Yes.
Right.
Yeah.
So we've put catalytic converter crimes back in, and the concern I have is kind of a similar discussion we had on the House floor today, which is we're adding exposure. I'm not sure that we're sure that that does anything. I mean, other than just, and this is really the question, other than just this amorphous idea that we're strengthening the law by increasing criminal penalties, is there another policy justification I should be made aware of for why we're creating a specific offense just for used catalytic converters?
Well, I think your concerns in the subcommittee, which I understand was the per se violation or the per se possession would constitute a violation. This is new or should have known. I mean, and these catalytic converter thefts are rampant across the state of Georgia right now. And so yes, to your point, this is adding a provision, but it's needed.
Okay, Mr. Chairman, I'll wrap it up. Just basically, I mean, I'll take a position against the bill just because, that's what I said I would do if this came back in. I mean, the concern is, I think, ironically, the forfeiture stuff from a political perspective would have been more likely to sink the bill on the floor. So it's understandable why the forfeiture stuff was removed. Politically, that's smart. But you're going to get the sort of red response, meaning on the board, not party, from, this increased penalty, which, again, it's unclear other than just jacking up penalties what it does. I think that's the objection. And I get that you still have to have mens rea. You still have to know or should have known it was stolen, but that's duplicative of something we already have an offense for under current law. So I just wanted to flag that opposition. Thanks, Mr.
Representative
Chairman.
McLaurin, you and I agree on this point. I brought up that it was already an offense to receive stolen goods, but the problem that we're seeing here is special. From the industry, they're telling me that people are. I had one friend of mine tell me that an entire landscaping outfit, someone jumped the fence and took off all of their catalytic converters, like specifically the catalytic converter because it has value. So we're making it we're calling it out specifically in code, so that we're trying to target this act that we're trying to prohibit, or stop. So I agree with you, but maybe from a policy perspective, we're trying to target this action that we do not want to continue to occur.
So
Please respond.
Thank you. As a quick follow-up, I mean, we agree that there's, I Googled the penalties section on my phone for receiving stolen property, but, so I'm looking at OCGA 16.8.12, which is the penalties section for receiving stolen property. And A1C is, if it's at least $1,500 in value, that's 1 to 5. Trial judge has the discretion to do 5 years for one item that has more than $1,500 in value. And I mean, based on previous testimony, right, we know that these are pretty lucrative things to steal, right, which is why it's such a problem. I mean, I would say one is over $1,500 in value, correct?
$1,500?
Yeah.
I think the metal inside palladium and I think it's $150 per pound. Most catalytic converters have up to 2. Certain vehicles, I think F-250 or F-150 has about 2.5 pounds. So you're looking at $300, $400 per.
And I heard most I've heard is $750.
Yeah.
So
$750. Okay.
Yeah.
So and obviously if you stack a bunch of those, then that's some level of exposure. I would imagine that they could be prosecuted as one group, right? One felony for the total amount, right? So, again, this is just questions I think we should be asking, right? It may take decades for us to get this right, but let's ask these questions out loud, right? I mean, if a trial judge can slam you with 5 years for something, I mean, do you know how much change a person goes through in 5 years, right? I mean, especially in the hellhole in our prison facilities. At some point, it's almost like we're just moving chess pieces around without thinking about the human toll. Why do we need more than 5 years for this? 5 years in prison, in these prisons, right? And so I guess my question is, like, look, we can say strengthening all day. Like, we're going to make these laws tougher, and that's good messaging. But from a public policy perspective, what does it do? And that's really the question I want to impress. So thank you.
Thank you, Representative McLaurin. It tracks the same punitive damages or punishments that we've already have for receiving stolen goods. We're not changing that structure. Now, you want to have the overarching conversation, and I do too, frankly, with you. But we're not doing that today, and I respect the gentleman's opinion, and thank you for your engagement.
Let's schedule a day and do it. Thank you, Mr.
Chairman. I'm going to call on let's call him the co-architect of this bill, Chairman Setzler, to give us the subcommittee report on 591, and I believe he's got a amendment to make as well at the appropriate time. Chairman Setzler.
Thank you, Mr. Chairman, members of the committee, members of the public. SB 591 had a pretty substantial hearing in subcommittee. There was some parts that came over from the Senate that have been de-scoped from this. One change there was some discussion around civil asset forfeiture, creating sort of a parallel and distinct civil asset forfeiture structure than what's in existing law. That was taken out. That's not in this bill. and another thing in this bill that was wrestled with but is no longer in this bill, was the proposition of a per se crime for possession of not just a catalytic converter, but also a whole series of metals. The idea that just the simple possession of it was in itself, without intent, a crime, was something that was troubling the subcommittee, and that came out. So what's before the full committee, Mr. Chairman, what came forward with the DuPass recommendation was a version that led to the substitute. The version, in essence, Mr. Chairman, dealt with the cash payments, allowing cash payments under $100 for a limited subset of metal materials, and then also the policy objective to come forward and address the catalytic converter issue, which is in the substitute that's being offered today. That was not passed by subcommittee, but was postponed from consideration so that we weren't going to pass something that was not really thought through and the language was not appropriate. The sub that's being offered today, Mr. Chairman, with the catalytic converter language has been worked through, and it's not a per se crime for possession. It does require knowledge that something was stolen or likely stolen, which again mirrors exactly the language of theft by receiving. So in essence, it's a theft by receiving of catalytic converters, and I would also have an amendment, some further that did not pass through subcommittee, but I think would be well advised for this full committee to consider, and I'd be glad to speak to that at the appropriate time.
Thank you, Mr. Chairman. We have no one signed up to speak to this bill, and no more questions. Seeing no more questions, I'd entertain a motion. Move to pass in a second on the underlying bill, Senate Bill 591. Before we move into discussion, are there any amendments? Go ahead, Chairman Setzler.
Thanks, Mr. Chairman. I've offered the amendment that's been drafted. Let's council got us the underlying version, but we've worked carefully. This is actually language that was lifted exactly out of the as-passed Senate substitute. So this is not something we just cooked up on the fly. It's been created from that. It's pulled out. It's word for word. It's a copy and paste in the page you see. But what this does policy-wise, I'm going to explain it to members of the committee, is closes a loophole that was inadvertently created by the work of the subcommittee that would have allowed the sale of catalytic converters outside of registered secondary metals recyclers. We've set this system up that's been successful for the last 11 years, which creates a requirement generally to sell metals with regulated recyclers. What that does is you have to take a driver's license, you take a photo, that whole process that documents the person conveying these materials over to, again, dissuade folks from stealing these things and running and getting them sold off quickly. Folks have to go through this process that's been very, very successful. Candidly, our state's been a model of the last 11 years of that. The substitute that came through the committee failed to acknowledge that without this amendment, we'd be allowing folks to take catalytic converters, sell them openly on the open market outside of secondary metals recyclers, arguably, and then also solicit for the same. What this does is it closes that loophole to make sure that catalytic converters can only be sold to secondary recyclers. Otherwise, you've got this handoff, and you could try to sort of launder these things through different transactions, and you can never track these things. This just recognizes that they can only be sold for money with a secondary recycler, and then also the advertising piece. This section 1.5 below, again, this prevents a loophole that effectuates the same policy, Mr. Chairman.
Thank you, Mr. Chairman. Before I go any further, I failed to recognize Judge Brenda Weaver is here with us from the Appalachian Circuit. Good to see you. I apologize for not recognizing you earlier. So we're in the posture of amendments. Chairman Sessler has offered an amendment before you. Do I have a second to this amendment? We'll call it the Setzler Amendment.
And Mr. Chairman, I would like to also, if I could offer to if it pleases the chair, I'd love to get the thoughts of the author on the amendment.
Yes, thank you, Mr. Chairman. I would be in support of this amendment. What this does is this cracks down on an issue that we're seeing where people will advertise on Facebook, social media, Craigslist, that they'll be having a catalytic converter, buy in a certain area. They'll set up a tent in a parking lot, Walmart parking lot or something, and they'll buy used attached catalytic converters. When these sales occur, within a certain radius of that area, catalytic converter theft obviously goes up. And so if we could prevent these from occurring, I think it'd be good, and I think this is a very good amendment, and I appreciate Chairman Setzler for working on this.
All right, we've got a motion for the Setzler amendment before the committee. Do we have a second? Second. We have a second. All those in favor of, we got questions. My apologies. Representative McLaurin.
Thanks, Mr. Chairman. Just very quick discussion on the amendment. I think the inserting between lines 81 and 82 paragraph about registered secondary metal recyclers really gets to the bottom of what this bill is all about. There's a business interest in making sure that these metals don't go through alternate pathways. Regardless of whatever moral opprobrium people assign to stealing, putting that to the side, it's bad for business if the registered secondary metals recyclers don't have the highest volume of these metals and materials, right? So, that's the thing I want to draw attention to is we're increasing penalties sort of on behalf of these businesses, and that's just something to think about. Thanks, Mr. Chairman.
Mr. Chairman.
Chairman Setzler.
Just to address the gentleman's question, I do think one could, with all due respect, perhaps take a cynical reading to this and conclude that. I would say that this legislature worked very carefully, really beginning in 2008 and kind of really concluding in 11 and 12, and then with some updates in 15, to put this program in place where if you can convey these kinds of products in scrap metals, you've got to be documented through a process where you're getting your picture taken, and you're really having to come online and not be hiding in the shadows in making this transaction. It's documented. You've got to sign affidavits saying that you testify these things are not, or affirm that these are not stolen materials. There's a whole process that documents, which keeps folks from sort of snatching and grabbing metals. That's been very successful in our state. Without this amendment, we're allowing a massive end around from that process that's really addressed the underlying root of crime. And I would tell you, if someone's contemplating crime and contemplating entering a life of crime where they're going to steal metals or catalytic converters, the prospect of having to go through this is, I think, a very direct deterrent. It's not deterrent by what you're going to suffer in prison. It's deterrent by what you have to go through at the point of sale, which is the kind of deterrence that what's a proactive deterrent. It's more of a lead measure, which I think it was wise for us to put in place in 11. And I think it would be wise for us not to create a big carve out for in 22.
Thank you, Chairman. Chairman Efstration.
Thank you, Mr. Chairman. I just briefly want to say, I'm certainly not going to question the members' motives in raising that issue before, but I think it'd be wildly unfair to cast motives or assume motives based upon support for the bill. So, I remember prosecuting offenses where you would have multiple air conditioning units. That's what were stolen in the aughts. And it was during that, the housing crisis, there were foreclosure crisis that was taking place. And the difficulty in tracing and connecting the recycling to the person who was believed to or seen to have been removing air conditioning units at the time. To prove beyond a reasonable doubt that in court, it's incredibly difficult. And that really, I think, brought about Senator Unterman's work on this recycling bill that we saw initially the first time. There's apparently now an epidemic of stealing catalytic converters, which, we're hearing about certainly in the legislature. But, my perspective on this is that the prosecuting these offenses, the necessity of tracking these types of transactions that are occurring is apparently something that needs to be addressed. And in my mind, there is no business, factoring into it. I remember opening those files and trying to piece together how you could make a case where the evidence seemed to be there, but because of similar protections that we had in, say, the pawn industry, you were able to make those cases a lot easier. So I certainly wouldn't challenge the what's going through the minds of other members as they review this. And finally, I will say this: I certainly don't want to have a debate over this issue, but we've worked extensively on criminal justice reform so that a 5-year penalty that's available to a judge in cases, first of all, is parolable. Even if 5 years is pronounced from the bench, that doesn't mean that the person is going to spend 5 years in prison. And I think it's bordering on, well, I think that that needs to be made clear. And if it's probated, which is available, if it's probated, that person is contacted by Department of Community Supervision after 2 years to be told that their sentence can be discharged early. So to repeat to the cameras over and over again, 5 years, I think is not what's occurring in practice. And I think that folks listening to this and with a genuine intellectual interest in these issues need to know the full story. Thank you.
Thank you, Mr. Chairman. I'd also point out that there's nothing in this bill prevents a lawful individual from taking their own catalytic converter to the scrapyard. So, I mean, this is trying to discourage nefarious activity, and the amendment itself, I think, speaks to the the actions of a organized sort of criminal underbelly that's trying to solicit or increase the stealing of these converters. So I think I'm have to side with Chairman Efstration on this one. Let's we've got a motion, we've got a second. Let's vote on this amendment that's before the floor. For the Setzler amendment, all those in favor of the Setzler amendment signify by saying aye. Aye. All those opposed? No. All right. It's the opinion of the chair that the amendment passes. So we have amended Senate Bill 591 LC 280536S, and to the committee we've got a motion to pass and a second. I'm going to call the question. All those in favor of passage of Senate Bill 591 as amended signify by saying aye. Aye. All those opposed? No. Congratulations, you pass on the rules.
Thank you very much.
Thank you. You can do that? All right. All right. Senator Hatchett, don't go nowhere. We've got a couple of your bills.
Staying in the hot seat. They're all just easy.
I'm going to take the 441 piece up. That's going to probably take a little bit of time, so let's go ahead and knock that out if we can.
441?
Yes, sir.
Right.
Senate Bill 441, LC 490996S is the LC I have.
Thank you, Mr. Chairman. That's what I have as well. Let me kind of start with the background of this bill. In the state of Georgia right now, there's a criminal database. For whatever reason, there's 7 million charges right now that don't have final disposition. So those that were found innocent or reached a plea deal, their final charges are not updated. Those that were found guilty, their final dispositions are not updated. So, you can, if I was found innocent and I go to apply for a job, the background check would show those charges as pending. If I was found guilty and I applied for a job, those charges would not be updated. So it's a public safety issue. It's an issue that is near and dear to several people, or a lot of people across the state. And we have actually every senator in the chamber, we have 56 sponsors of the bill. It passed unanimously. We have gone through all the stakeholders, the clerks, from the clerks up to Supreme Court justices and everywhere in between. And the problem, it's hard to point your finger at where the system is broken. Why are this many charges not updated? And what we're doing is looking for a solution for this. And what we've decided and what we're attempting to do with this is to come up with a uniform set of rules that apply, that will hopefully in the near future help lessen this backlog and in the future prevent it from happening again. There's a lot of support for this bill. It's a long bill, but it just shows the work that's gone into it. And I'm happy to take specific questions about it if there are any.
Senator Hatchett, if you wouldn't mind, being this piece didn't go through the subcommittee process, would you mind just sort of going section by section with us? I don't want to, you don't have to dig into every period and comma, but just tell us what each section's doing.
Yeah, Mr. Chairman, I'd be happy to. Let's see.
And I know you have some call of friends in here. If you want to phone a friend, we can have them come up and help out, because I know this is a significant piece of legislation with a lot of moving parts.
Yeah, this was taken on by the Lieutenant Governor's office as a priority, and we've spoken with, like I said, a lot of stakeholders. But basically, I can try to go through section by section here. So section 4, the first few sections are obviously just kind of definitions and teeing it up. But section 4, it's there's a criminal case data exchange board that's in existence now. What we're doing is we're changing their responsibilities. They will be responsible with coming up with uniform standards that would apply to clerks in entering this data into the database in an attempt to hopefully get everybody on the same page so we can clear up the backlog. Section 5 has a lot of definitions. I wish I had, hang on a second. Here we go. Okay, so Section 5 reconstitutes the Criminal Case Data Exchange Board. Section 6, this pertains to the duty of the Superior Court clerks. It removes several outdated references, including reference to the I'm trying to find. Let's see. Basically, it basically cleans up the duties of the Superior Court clerks. I have a couple people that could come testify.
Mike, you want to come in, and jump in there, and
it's a very lengthy bill, but it's a very good bill.
No. Mike, you want to come in? Sure, come on up and help us out here.
If you need
No, I've got it right here. That section,
Will you take that mic
yes,
for me and tell everybody who you are? I know who you are, but
I'm Mike Holloman. I'm here representing Superior Court clerks,
mm-hmm.
and I concur with everything that Senator Hatchett said so far, in that this is a real problem, and there are many fathers of the problem, and it's going to take the involvement of prosecutors, clerks, judges, sheriffs to fix it. To the modernization language, what that section does is it removes a reference to the Superior Court clerk's authority. They have been simply involved in this because at the time that criminal data was required to be electronically transmitted, going back to the Barnes administration, they had the only conduit into every courthouse in the state. As many of you know, the authority is a real estate-oriented entity and has nothing to do with criminal. So we're taking that out because now, 15, 20 years later, there are multiple avenues to get access into these case management systems. I'll not take over just any other questions that come up. I'd be glad to answer.
you need
But
the bill.
all right.
no, I've got it right here. I've
So,
got it.
do you want to move on to the next few sections?
Well, if you're available to help
Okay.
with like go section by section.
Section 7 just directs the council, now puts as a duty of the council to create uniform rules for how this data is transmitted. It puts in the purview of the larger Criminal Case Data Exchange Board, of which clerks are a member, but also include some 24 other members. It charges that larger group with promulgating standards for this across all of these agencies.
So talk about the data we're talk about.
The data is everything from the warrant. It's the obits form that the sheriff creates when they book a person. Those obits forms, in some cases, are not being done, not because the sheriffs aren't doing it, but because the charges are upgraded further down the pike, and they were originally booked on a non-fingerprintable offense. It becomes a fingerprintable offense. The obits form, offender-based tracking system form, has critical information that if you don't have, you can't ultimately get it into GCIC. So again, small rules. The council has now authority to create rules for clerks on how we do this. That would include standards. One of the objectives of this bill, and there are three main ones that I see, is to create criminal e-filing. And we want to be sure that we capture as much of this information through an automated criminal e-filing system as possible. That will greatly advance this information getting down to the end of the line when we turn around and try and send the disposition to GCIC.
So we're looking at, essentially the impetus for the bill is to make sure that when we're looking at GCIC, that we have a full picture. We're looking at the entire picture, not
Yeah.
some parts that are missing that are not currently getting input, right?
That's correct. What happens is there's an arrest, count 1, 2, 3. Then there's an indictment, count 1, 2, 3. Well, those often change, as Chairman Efstration knows. And then there's a disposition, and it can indeed often changes. All of those changes have to be accounted for in the GCIC system, or when the clerk, at the end of the day, transmits their disposition information, GCIC system kicks it back. And that goes to the point that Senator Hatchett made. It's not only an issue of not having accurate criminal disposition available, it also harms individuals who maybe had their charges dropped or they were found innocent. Then that arrest is sitting out there until they show up at the clerk's office with their story, and the clerk goes in and manually edits it out of GCIC system so that those arrests go away.
Is the council going to be able to promulgate rules that have the prosecutors also inputting their data at a certain time?
I think that'll be part of the larger board's rulemaking. Again, there's two rulemaking processes here. The Criminal Case Data Exchange Board will promulgate rules, and it says here that the council shall promulgate rules not inconsistent with the rules for the entire criminal justice system. So there will be rules that apply to prosecutors. There will be rules that apply to everybody that come out of this collective effort by this large board.
All right.
But I think prosecutors, clerks, and sheriffs and judges are the key principal players to this whole thing.
Would that include police chiefs and?
It certainly could. That's not my, municipal side's not my area.
That's
but
your area.
yes, certainly there are charges that need to get into GCIC at municipal, and this bill does address state court. It
All
sort
right.
of mimics the language that you see in the first few sections. It just repeats that for state courts.
You want to go to section 10, Mike?
Well, GCIC and GCIC, I didn't mention them as being a critical player, but clearly they are. The rules around how their software system requires this data to conform along the way is certainly a piece of the problem. Advises. Yeah,
Okay.
it just tells GCIC, it looks like that they need to align their policies with policies as adopted by the Criminal Case Data Exchange Board and the Council of Superior Court Clerks. And it's a pretty big piece too.
All right, section 11.
It's just reporting requirement.
So, yeah,
Oh,
with section
yeah.
11, sorry, and I found my working copy here. So this is another requirement on GCIC. Right now, they already issue their reports, but it's not codified in current law, so this just formalizes the reporting process.
Yeah. And that will be important information to gauge the success of what we're doing along this process.
And then section 12 is important. It's 35336 is the governing statute for getting all of the criminal record information to GCIC. So this basically, any agency in Georgia that has a role in criminal arrest and prosecution would have to, that's the criminal justice agencies. They're online. Let's see. Line 302. This brings in prosecutors and other criminal justice agencies that would be required to do this as well.
All right.
Section 13, 14, 15, 16, these are conforming changes. And let's see, is there section 16? Yeah, section 16 upon enactment. This basically allows for the Technology and Empowerment Fund, and that's where the funding in the budget is. It's in the Technology Association, or excuse me. It doesn't go directly to the clerks. There's actually a fund that's going to fund this, and in the budget, it specifically references Senate Bill 441, and I believe it's.
I recall seeing that.
Yeah.
Now, Mike, let's talk about that, because that's the portion we've sort of been holding on, and
Yeah.
I want to make sure, because you've expressed that the clerks are capable of promulgating these rules, but it's going to cost time and money. So can you tell me what your thoughts are on that?
Yes. There is a separate discussion going on around House Bill 911, and it exactly goes to a line item that exists under the GTA's budget right now. That more appropriately needs to be, in our opinion, in our section of the budget. Now, what Section 16 also does something entirely different than the project planning money, which is a relatively small amount. It's like $350,000. This technology empowerment fund, as I understand it from the powers that be, and as Senator Hatchett mentioned, there are a lot of interested parties, executive branch, Senate, House, who are interested in this. This paragraph is here for when the big money is identified. There's been no identification. This project's probably a $20, $30 million project over 5 years, let's say. I'm just making, but it's big. And there has to be a place to park tens of millions of dollars. And, council would be glad to hold it, but, there's obvious reasons that the state would like to have a more defined process for doing that. So as I heard this described to me, this was a place that you could park 20 million, and then the council, Superior Court clerks, and the Criminal Case Data Exchange Board could identify counties and circuits that have signaled their intention to comply with the standards, and that they would be then eligible for a release of funds to enact criminal e-filing or automated data exchange networks. We can't confuse that $350,000 is not the money that I heard is envisioned to be earmarked for this technology fund. In the past, it had been a Criminal Justice Coordinating Council.
Very good. Do we have any questions from the committee? No questions. Let's hold on to this piece. Let's not vote it today. I got a further question, follow up offline with you,
Okay.
you and the author. I don't have any problem with the legislation, but I just want to make sure we've got our ducks in a row with this funding piece, to make sure that we're not getting the cart before the horse, sort of thing.
Okay.
So let's have a conversation offline about that one. Thank you. Senator Hatchett, we've got another Hatchett bill. By the way, Senator Hatchett requested all 4 of these bills on Wednesday. Senate Bill 539, LC 339086S.
Thank you, Mr. Chairman. This is Senate Bill 539. It is a Department of Public Health bill. This is in response to concerns with patients being filmed in waiting areas and other areas of Department of Community Health. The HIPAA laws that protect patients don't apply to other members of the public or other patients in waiting rooms and areas like that. So when people were being filmed for various reasons, whether it was to film a long line at a clinic or to put a video on TikTok or something, when the members of or the staff at these health clinics tried to call law enforcement, there was no protection, or there was nothing the law enforcement could do, and this just extends that protection for patients' privacy from the clinic itself to members of the public that are using a device. So what it says is if you're going to film or you're going to take pictures at a health department, you have to have consent of all parties observed.
All right, very good. Thank you, Senator. And the department has requested this.
They
correct?
have,
Thank
yep.
you. Chairman Abstration.
Thank you, Mr. Chairman. So, Senator, you'll recall there's been legislation around the recording at nursing homes. So there's been a discussion that we've had here at the Capitol over the past few years about whether or not that is or should be appropriate, is or should be authorized, and if it is, what the circumstances will be to allow for such recording. Does your bill in any way impact recording at nursing homes?
No, and that was actually a concern that was brought up, and so just to clarify that, we made it to where it only applied to county-owned health facilities.
Okay. And so if someone is concerned that there may be abuse that's taking place against a patient who's unable to report that abuse, your bill in no way would prevent what is otherwise legal recording from taking place.
No, anything that has to do with security cameras or anything that is in the normal course of, I guess, in scope of a medical facility would not be, this would not be prevented.
And would you oppose any attempt to amend your bill to allow for something like that?
I would.
All right, thank you.
Any further questions from the committee? No further questions from the committee. Senate Bill 539, I'll call the question. Do we have a motion?
So moved.
A motion? Have a second? Any amendments? Hearing none. All those in favor of Senate Bill 539, LC 339086S, signify by saying aye.
Aye.
All those opposed? Bill passes on the rules. Congratulations.
Thank you very much.
I've got one final bill. Senate Bill 10. Where is Chairman Smith is probably coming in here. Chairman Smith, I'm going to turn it over to you for Senate Bill 10.
Thank you, Mr. Chairman. Today, members of the committee, I bring to you a substitute to Senate Bill 10. This is LC number 480622S. And you'll see here, I'll go through just real briefly for everyone. Section 1, that concerns the impersonating of a officer of the court. We have added that actually to this, to the impersonating an officer statute. That would include those that are officers of the court. That would include the attorneys that practice before our courts, as well as the clerks. And so we made that change to the statute, real simple change there. Section 2 was something that I appreciate the discussion yesterday in subcommittee about this, and this is concerning the intentional and clandestine manner of placing a global positioning or monitoring device, which could also be usually is an electronic monitoring device on a motor vehicle, and we limited that to situations where an individual has a protective order. And you'll see those statutes there that concerns TPOs, protective orders / consent order or consent agreements. And then 19-13A-4, that is our dating violence protective orders, which this committee has so wisely put into our code section. And then section 3, this is our what we're calling our driver's license bill. This will give judges the discretion on whether to revoke a license or have it reinstated for failure to appear to court. I can tell you in personal experience, Mr. Chairman, that when you have a client that doesn't have a driver's license, if they're not qualifying for indigent defense, then you take that driver's license away from them. They can no longer pay their defense attorney. They can no longer pay their bills at home, and issues just continue to mount up. You really pouring gas on the fire there. So this is a good bill that was brought to my attention. It has the support of our Chamber of Commerce, Georgia Justice Project, Georgia Municipal Courts Association, and several other organizations. I don't have all those letters printed out with me, but we've got a good bunch of folks behind this, and I think this is good for our state and good for the people of this state as well. So, Mr. Chairman, in summary, that's the bill. I appreciate the diligent discussion yesterday, and would ask that this committee favorably consider it and vote it out.
Thank you, Chairman Smith. I'm going to call on Chairman Sessler to give the committee subcommittee report.
Mr. Chairman, I think Vice Chairman Smith nailed it. That was really the discussion. We did discuss, I think, the possibility, although it wasn't the will of the subcommittee or I think this committee, to address some privacy concerns that have presented themselves over the years, both in some cases that may be a little vague in this code section, but beyond that discussion we decided not to act on. I think this is something we can move forward with confidence in. I think there's no real hidden surprises in this we need to be worried about.
Very good. Thank you, Chairman Setzler. I do know that the Metro Chamber is in support of the bill, correct? All right. So is there anything else you wanted to say besides that?
No. We appreciate your favorable consideration.
Okay. Thank you.
Mr. Chair, I would say one thing that just is a fine point, that this ability to get one's license back at the discretion of a judge does not apply to cases where you would automatically lose your license, like in a DUI case. There's, death by homicide by vehicle. Those would not be eligible for this, but for lower level cases, it would be.
Thank you. Representative McLaurin.
Representative Montana. Yes.
Representative Montana, sorry.
Okay. Thank you, Mr. Chairman. I'm not going to say it. I'm not going to say it. On that subcommittee, so this is the first time I've seen it, Mr. Chairman. How'd you go on there? I wanted to make sure, I think he just clarified it for me, but for the, tell me a little bit about the other, I know where are we specifically making sure that folks who, you said homicide by vehicle or anything like that, obviously they need to lose their license. That's still happening. Is that right? Chairman Setzler?
I'll pull the code sections up here. Give me a second.
Okay. I just want to make sure. I didn't see that in the bill, but I may have missed it. Of course,
If you would introduce yourself there. And
Title 40 is a very confusing.
Thank you, Mr. Chairman. I'm Wade Askew. I'm a supervising attorney at Georgia Justice Project. And so my lines might be one off because I'm looking at the substitute version for yesterday. There was a very minor edit that might have just shifted it one. But it's either it starts at line 61 or 62. This subsection shall not apply to any violation of Title 40. Then there's 3 circumstances listed there.
Can you list those for us? Those. Oh, thank you.
Thank you. The 3 circumstances that are listed here are first, for which a driver's license may be suspended for a first offense by the Commissioner of Driving Services. Essentially what that means is if I'm pulled over, if I'm cited for an offense where just by virtue of that offense, if I'm found guilty for the first time, I can have my license suspended. This is saying that this provision here is not going to help me. And then subsection C there for offenses covered under Article 15 of Chapter 6, that's really talking about your DUIs, your drag racings, your homicide by vehicle, your serious offenses. So essentially what that's calling out is this bill is designed to say if you have a driving offense where even if you're found guilty, you wouldn't get a suspension. It could be I rolled through a stop sign without a full stop. I went 5 miles over the limit, something like that. And then I show back up in court. Now just give me a mechanism to get my license back that does not currently exist.
Chairman Sessler.
Sure, I was going to, 40-5-54 mandatory suspension of license. One of the sections for which a list of offenses would not be applicable to this treatment. You'd still necessarily lose your license is 1, homicide by vehicle, 2, any felony in the commission in which a motor vehicle is used, hit and run, racing on highways and streets, so street racing, fleeing or eluding an officer by motor vehicle, and operating a motor vehicle with a revoked, canceled, or suspended license. So those are things that you'd still lose your license for that would not be eligible for this. And that's the 40-5-54. And there is another one in addition to that, but that just kind of gives you a picture of what's kind of the arc of this.
Thank you, Mr. Chairman. That was my question, just making sure,
Thank you. Thank you, Mr. Chairman. Thank you, Representative Montahan. Any further questions from the committee? No one signed up to speak? Then I'll call the question for Senate Bill 10, LC 480622S. All those in favor signify by saying aye. Aye. All those opposed? Aye. All right, measure passes on. With that, we're adjourned.